Assalamualaikum warahmatullahi wabarakatuh. This is part 2 for the recorded lecture on the topic contributory negligence. So in the part 1, we have covered up to elements. Okay, we stop at the case law. We discuss some of the cases. So for this part, we are going to focus on two subtopics. Okay, the first one is agony in the moment or agony of the moment. And the second part is contributory negligence by children. What are the rules governing that particular circumstances or situation? Okay, for agony in the moment, basically the rule requires that defendant cannot escape liability if the plaintiff in the agony of the moment tries to save himself by choosing a course of conduct that proved to be the wrong one. So this argument based on agony in the moment actually will be useful for the plaintiff to defend his case so that he could be blamed for the action that he chose at that particular moment of time. And because of that, plaintiff does not contribute negligence if he acted in a reasonable apprehension of danger and the methods by which he tried to avoid it was a reasonable one. Let's say there are two methods, two choices, whether to jump or not to jump, and he chose to jump and he suffered injury, severe injuries later, for example. So defendant cannot argue or put the blame on plaintiff for choosing such an action in that particular moment, agony in the moment. So agony, I put here the definition of the word agony. Agony means extreme physical or mental suffering or the final stages of a difficult or painful death. So mean that here difficulty, difficult, especially to decide in a very difficult situation in that particular moment of time. So no time to really think about it, rethink or rethink again and again for that agony in the moment. So we have these two cases to illustrate to us the rules of agony in the moment. For example, in the case of Govinda Raju and Laws, 1966, the court held that what was done or not done in the agony of the moment cannot be fairly treated as negligence. So we cannot impose liability on the part of the plaintiff because what happened, whatever act that he chose in that agony in the moment. And in the case of Cho Nina and Syarikat Beruntung Semberat, reported in 1989, it was held that the deceased was not in contributory negligence because he was in the agony between remaining in the lorry driver's seat or jumping outside the lorry in order to save himself. So whatever act between the two acts here that he chose, so it was done in the agony of the moment. So there's no liability imposed, no negligence on his part for choosing such an action. Okay, let's have a look at the facts of Govinda Raju and Laws. This is reported in 1966 in MLJ. So defendant turns right at the junction while plaintiff on motorbike was oncoming from opposite direction. So defendant was turning right and then there's plaintiff on motorbike from opposite direction. And plaintiff tried to avoid and swerve right, but finally he knocked the rear side of defendant's car. He was trying to prevent the crash basically to avoid the crash, but still it knocked the rear side of defendant's car. So the court held that defendant was negligent in turning the right at the junction and what plaintiff did for trying to avoid and swerve could not amount to contributory negligence because when the plaintiff is perplexed or agitated when exposed to danger by the wrongful act of defendant. So it was defendant who did the act of negligence by turning right here. It is sufficient if he shows such judgment and control in attempting to avoid the accident as may reasonably be expected of him in the circumstances. So whatever act he did in trying to avoid and by swerving right, actually this is something which was reasonable for that particular moment of time. He was in agony of the moment. So there's no blame, there's no liability can be imposed on the part of the plaintiff for taking such an action, something which was reasonable. So that's basically the discussion for agony of the moment. You might have some more cases in your textbook, so you can refer to see how the court apply this particular rule. Now we go to the second subtopic, second part of the lecture. For this part, Second, this is another important rule, okay, pertaining to children. Okay, what's the liability of children? Okay, contributory negligence imposed on children. So most of the time, the court will take into account the age of the plaintiff. How old was the children? Okay, was the plaintiff, in considering whether we should impose liability or not. Okay, so it depends very much on the circumstances. So the older the child is, so the higher degree, okay, reasonably be expected from a person in that plaintiff situation. So degree imposed on 7-year-old child will be different compared to 12-year-old child. So one of the leading case involving liability of children is the case of Lembaga Electric Negara, Malaysia and Ramakrishnan, reported in 1982. This is a appeal case. So respondent was a 10-year-old boy, and what he did was that he climbed up a hedge pole, so the pole with the shape of hedge, right? And this pole was erected and maintained by the appellant, by Lembaga Electric Negara. Nowadays, it has been renamed to Tenaga Nasional Berhad, TNB. And what was respondent trying to do? In an attempt to release her, he climbing up the pole to release a bird which was trapped on the wire of the pole. And in doing so, okay, he's just a boy, okay, 10-year-old boy, and in 1982. So respondent was electrocut, okay, and suffered severe injuries, okay. So the court held that, what's the liability imposed here? So the court held that expressly, the test is whether an ordinary child of the respondent's age, to 10 years old, and experience, okay? So we don't actually expect neither a paragon of prudence, meaning that you're excellent, okay, of wisdom, nor scatterbrain, forgetful. It's not below the level or very high beyond the level. Okay, would have taken any more than did the respondent. So it's just average, okay? Average ordinary child. For example, a certain child has a very high IQ, some child very low IQ, but we just take the average one, okay? So basically, that's how the court, the court decided the case lah. There's no contributory negligence on the part of the respondent. Is it here? Yeah, respondent. Okay, another case also involving a child here. Sharizan bin Sudirmin and others, and Abdurrahman bin Bukit and another, reported in 2010. So the first plaintiff was riding a motorcycle. They were the second plaintiff. There were two of them as pillion, when he noticed a group of policemen conducting a traffic inspection in the distance. So he can see, okay, police was doing the roadblock. Okay, at a matter of time, both the first and second plaintiff were 15 years old, underage, so no license. So first plaintiff was not licensed to ride a motorcycle. Neither he nor the second plaintiff was wearing a crash helmet. So no license, no helmet. Okay. So the first plaintiff, the one who ride the motorcycle, he made a U-turn and sped away. He was trying to run away, basically, okay, escape, in an attempt to escape the policeman. And the first defendant, who was defendant, the policeman, okay, a policeman in the group. So he got on to his motorcycle because he can see, oh, you are trying to run away. Okay, so he got onto his motorcycle and he chased after the speeding first plaintiff. So they were chasing after each other. Okay, the police is chasing after the defendant. The plaintiff, the two plaintiffs here. When the first defendant drew alongside the first plaintiff, he kicked at the first plaintiff motorcycle. He was trying to stop him actually, okay, causing the first plaintiff to lose control and crash, cause accident. And both the first and second plaintiff sustained serious injuries. And the first plaintiff was rendered paraplegic, paralyzed, okay, and became wheelchair bound. So he became disabled. All right, and this is what the judge said, V.T. Singham J. This is from the judgment. In attempting to escape apprehension in the police pursuit, okay, the first plaintiff took a serious risk, okay, to himself and other road users in riding his motorcycle at such fast speed. So speeding, okay, you put yourself to the risk of injury, and also it might affect other road users. Therefore, this court finds the first plaintiff had also contributed to the damage he had suffered. So whatever injury he suffered actually due to his own act as well. Okay. Accordingly, the damages have to be reduced as this court finds having regard to the first plaintiff shares in the responsibility for the damage. So meaning that here there was contributory negligence imposed on the plaintiff here. Of course, a defendant was liable, but not 100% liable. Because why? Plaintiff contributed to his own injury by trying to escape, riding at a very high speed, fast speed here. And then on the part of not wearing crash helmet, okay, a reasonable prudent motorist in the position of the first plaintiff position, 15 years old, okay, would have foreseen that the wearing of crash helmet might result in less harm or injury being caused to his head if he's involved in the collision. So accordingly, there should be a deduction on the damages to be awarded for his head injury. Remember the case that we discussed in the first part, okay, that one, even though without wearing crash helmet, the rider, okay, that didn't suffer head injury. Here, he suffered head injury. And then, of course, it is partly contributed to him not wearing crash helmet. So cannot get the full claim, okay, of the amount of compensation. So how the court decided the case? Accordingly, liability should be apportioned at 75% against the first defendant and 25% contributory on the part of the first plaintiff for his want of reasonable care, less of care, for his own safety and failure to wear a crash helmet that had contributed to his head injury. Okay, that's all for the topic contributory negligence. Stop share for now. So hopefully you have benefited from both of the videos. So I'll see you in the class. Assalamualaikum warahmatullahi wabarakatuh.